Okay, part four of De-Risk Your Biz. Minimum company setup documentation required. It's a mouthful, isn't it? So here's the deal. If you choose an LLC, you can have what I've called the napkin contract. I'll boil this down for you. There are 5 states that require a written operating agreement. Okay. I'll actually tell you what they are up front: Delaware, New York, California, Maine, and Missouri. And since late 2023, 2024, those were the 5 states in the US where you have to have a written operating agreement. No other state for an LLC requires you to have a written operating agreement. Okay. So what I say is you technically could write it down on a napkin. I list out these 7 or 8 questions. These are main questions and points that get people in the most trouble. Okay. And what I say is, if at minimum you don't even feel like doing an operating agreement, you don't want to pay a lawyer, sit down, write down these questions. Everybody answer the question together, figure out how you want to handle these issues, and everybody sign and date it. Okay. That's your napkin contract. Minimum thing you could do. Everybody sit around and do it. Not recommended. I'm just saying you could do that. And I think you would probably mitigate 90+% of the risk of when it would come to corporate problems and partnership disagreements and all of that. Okay. Corporations, as we've talked about, it's a lot different in terms of the formality of shareholders and directors and officers and all of that stuff, the parliamentary procedure of it. So naturally, that is not a minimum. The minimum documentation required is much more significant than it is for LLCs. All the bells and whistles. Okay. So you need a certificate of incorporation, you need stock purchase agreements, you need stock certificates, resolutions, bylaws, meeting minutes. You need at least basic form of this long list of stuff. Okay. So if you're going to do a corporation, just know you've got to do all the parliamentary stuff and you've got to have your books in order. The secretary of the corporation is responsible for all this. Okay. No napkin contracts allowed in corporations. Okay. So that's the gist of the point of this. Okay. And another point that I really get to, earlier when I was talking about, if you go back up to the pyramid, I have these asterisks here. Watch for even numbers in your members, your shareholders, your board. Why? Because it can create deadlock. Okay. And you want to stay away from deadlock. Deadlock is another thing that veers you into legal risk. You have a lot of costs coming. Okay. So I say here, I highly advise against splitting up voting power evenly. Even splits are dangerous and require extra provisions in the paperwork to overcome deadlock. Okay. You need to put some buyout provisions in there. You need to decide some valuation of the company metric if you got to buy out a partner. Just don't do 50-50, 25-25-25 unless you have those other things. I always say, do 51-49. Make somebody step forward to be accountable for the company. Okay. So those are the main points of that. And next we're going to go to the finance department.